And I must say, I was deeply impressed by the diligency and the obvious informedness of the judges, all five of them. They had read the hundreds, if not thousands, of pages of documents. They knew the statements. They knew what was written in it. Once you put that level of evidence that comes along with these dossiers submitted to the regulator for approval of their products, once you put a independent mind to it that is not already, in one bulk court or another, and somebody looks at the evidence that is actually put in front of our regulators, there is only one conclusion, that it is too little and too late, basically, to submit and support the overreaching claims of both safety, lack of risk, and of efficacy. And I think what this shows also, that the whole court case and the action of Bayer, Monsanto, and the state, is they grew so used to that this is the gold standard level of what you have to submit to a state and a regulator to get your approval, to get away with your claims, that they were literally shocked to see that this didn't fly in South Africa at the highest level. And for me, as a European, working with European agency, where the same level of very limited data, to put it very politely, is submitted to, and also we're involved in court cases at our judicial systems here in Europe, or at state level, it was impressive to see how the arguments and the facts that Monsanto and the state were confronted with in their dossiers, asking questions like, how did your own assessment of a small risk on page X turn into no risk a few hundred pages down in your arguments, without providing the necessary data and evidence to support that claim that a small risk became a no risk. I had only, when I sat there and listened to the judges and the questioning of everyone, including the lawyers in support of ACB, to the core, to the bone marrow, as we say, I was really impressed, and I knew these were people who wanted to know the truth, basically, and wanted to understand how does this work.